our original schedule should be morning one. Okay, let's experience this kind of session also. I think it is good for me, but bad for you. Why? Because theory subject, continuous sessions. Huh? Okay, let's experience this thing also. Right, what was our earlier discussion? Types of, I think we completed the discussion regarding the types of directors, right? This thing. Types of directors discussion has been successfully completed. So, next, qualifications and disqualifications. Qualifications, disqualifications. It is a quite easy concept. At the same point of time, it has much more weightage from examination point of view. Let's discuss these qualifications and disqualifications and end the session. So, what is the actual schedule of this class? 7 o'clock to? So, 8:15. Okay. So, we will close this class just after closing the discussion regarding qualifications and disqualifications. So, if it is completed by 7:45, we'll close. 7:30, we'll close. 7:25, we will close. 8:45 also, we'll continue till 8:45. Okay. Let's make a deal. Yes or no? Yes or no? Huh? Whichever is lower. Whichever is earlier. Okay, right. So, okay, jokes apart, let's quickly jump into the discussion. So, we have discussed so far, our discussion went on till we start with meaning of director. Section 2, subsection 34. Director is a person who is appointed to the board of the company. Next, roles and importance of director. 5 points. After that, minimum number, maximum number. 1, 2, 3 and 15. 15 is not the limit. We can appoint more than 15 also by simply passing special resolution. After that, types of directors. In types of directors, executive director, non-executive, MD, whole-time director, independent director, nominee, alternate, additional, casual vacancy director, resident director, women director and small shareholder director. So, all this discussion has been successfully completed in the previous classes. So, RD is mandatory for every company or not? RD is optional or mandatory? Resident director is a mandatory appointment which should be done by each and every company, whether it is a public, private or even OPC also. In case of OPC, what is the minimum number of directors? That one director should be resident director. And the tricky point is, even foreign nationals are also eligible to act as resident director. The only condition which a person needs to satisfy is the period of stay. What must be the period of stay? 182 or next one, qualifications and disqualifications. Surprising thing is, Companies Act 2013 does not specify or does not mention any sort of qualification regarding the appointment of a person regarding as in the place of director. So, in order to act as a director for a company, there are no specified qualification from Companies Act point of view. Having no disqualification itself act as a qualification. So, we should know about disqualifications first. So, these are all the disqualifications. Disqualifications are quietly segregated into 3 parts. This section is very much important from examination point of view. The section number is 164. 164. It has 3 parts, 164.1, 164.2, 164.3. So, all the 3 subsections are very easy and very important also. So, first of all, disqualifications, 164.1. Let's quickly discuss 164.1. What is the name of 164.1? Disqualifications based on personal capacity. Disqualifications based on personal capacity. 164.2 name is disqualifications due to default by the company. Disqualifications due to default by company. 164.3 is additional disqualification as prescribed by AOA, Articles of Association. So 164.1, first one, unsound mind. So in order to appoint a person in the place of a director, he should not be an unsound minded person. Okay, next one, undischarged insolvent. What is the second point? Undischarged insolvent. And the third point is applied for insolvency and application is pending before the court or tribunal. 2 and 3 points are interlinked. I think you are all having proper knowledge regarding 2 and 3 points. Okay. So the insolvency process is you should make an application to the court. The court will decide according to the application whether the application has met with the proper criteria or not. The decision might be positive decision or it might be a negative decision also. So these are the interlinked points 2 and 3. In case of third point, he is saying that the person should not made any kind of application to the court or tribunal regarding the insolvency adjudication. And the second point is he should not be an undischarged insolvent. Undischarged insolvent. And the fourth one, disqualified by the court or tribunal. Some courts or tribunals will disqualify certain class of persons or certain persons, saying that this person is not allowed to act as director. That disqualification will be applicable according to section 164.1. Next one, achieved maximum number of directorships. With respect to directorships, I have already discussed in the previous sessions. What is the maximum number of directorship for a person? 20 directorship. Out of that, sublimit is 10 public companies, remaining private companies. Okay. Maximum 10 public companies only. So 13 private companies and 7 public companies allowed? Allowed. 13 public companies and 7 private companies not allowed. In this 20 calculation, 2 companies directorships will be, 2 directorships will be excluded. Number 1, section 8 company directorship is excluded and LLP directorship is excluded. LLP directorship. Read carefully. This 20 excludes section 8 company directorship as well as LLP directorships. Okay. So read carefully. Maximum is equal to 20 directorship, including public company directorship, private company, OPC, dormant company, including everything. The only exemption is 2 directorships. One is section 8 company directorship and the second one is LLP directorship. LLP will not come under this limit. Next one. At the same point of time, sublimit is equal to 10 public companies. Out of these 10 public companies also, the exemption is available for section 8 public company. I have asked a simple question. I think in the first session or second session, I have asked a question. Whether section 8 company is a public company or a private company. It is neither a public company nor a private company. Depending upon the nature of incorporation, it will be decided. A section 8 company can be started as a public company or as a private company also. Both ways allowed. Okay. So, it's a simple point. In main limit also, section 8 company excluded. Then why in sublimit it will be included? In sublimit also it will be excluded. So, in simple, in calculation of number of directorships, section 8 company directorships, whether it may be public or private, it will be simply excluded. I hope you all got the clarity regarding the section 8 point. Okay. Total number of maximum number of directorships for an individual person must be 20. Out of the 20, sublimit is 10. 10 what? 10 public companies. In calculation of 20 or in calculation of 10, which should be excluded? Section 8 company directorships must be excluded. Simple point. So, if you achieved that maximum number of directorships, So I am a director in 8 public companies, 8 and 12 private companies. Now 21st company is willing to appoint me as a director in that company. Is it allowed to do so? Why? Because I have achieved my maximum number of allowed directorships. I am eligible to act as a director in maximum 20 companies only, and the limit has been reached. So further appointments are banned. So I am disqualified to act as director in further companies. Okay, this is the point, and this is one of the important point. There is a practical question also. What is that point? Read that box. This box. Read the box. Read the content in that box. Read out loud. What is your understanding? ఎవరు? Yeah, exactly. Elaborate that point. Elaborate. What's wrong in the discussion here? Tell me. What is the meaning of that point? The meaning of that point is, as per Companies Act, the allowed maximum number of directorships are 20. But the company places additional restrictions. That means a company can restrict a person who is acting as a director in that company, saying that you should not accept more than 15 appointments, you should not accept more than 12 appointments. Why? Because the more number of appointments, say for example, number of appointments are increasing, then the quality of work will automatically will decreasing. That is why the company may place additional restrictions on the director, saying that you should, if you are ready and willing to act as a director in my company, you should not accept more than 15 companies. You should not accept more than 12 assignments. You should not accept more than 10 appointments. Likewise, a company can place additional restrictions also. Simple point is, you can place strict rules than Companies Act, but you can't relax the rules of Companies Act. Say for example, for doing a simple thing, special resolution is required. Say for example, for doing a thing, special resolution is required. You can modify in a stringent way. Say for example, your company's articles of association is saying that in order to do that thing, unanimous resolution is required. What is Companies Act is saying? Special resolution is required. What is the voting percentage of special resolution? 75%. Now, your articles of association came and say it is saying that not 75%, 100% voting is required. Is it possible to do so? Yes, possible to do so. Why? Because you are making the rule in a strict way. It is possible. You should not relax the rules. Say for example, 75% voting rule has been modified into 50% voting rule. Is it possible to do so via MOA or AOA? No, not allowed. Whether it is MOA or AOA, it should bind by the rules specified in Companies Act 2013. Which prevails over MOA and AOA is Companies Act 2013. Okay. In the same way, companies can restrict the directors regarding the number of assignments. As per Companies Act, maximum assignments are 20, but the companies may in turn place additional and strict rules and regulations also. It is depending upon the company and director's relation. We can't comment on it. Next one. This is the important thing. Imprisonment rule. This is very important. First thing, if a person went on imprisonment for a period of less than 6 months, say for example, a drunken drive case attracts and he went to 14 days imprisonment or 1 month or 2 months or 3 months imprisonment. If the imprisonment period is less than 6 months, no disqualification attracts to any person regarding the directorship. Nothing, no disqualification. If your imprisonment is greater than 6 months, if your imprisonment is greater than 6 months, then disqualification will attract, disqualified till 5 years from the expiry of that imprisonment sentence, not from beginning of imprisonment, from the expiry of, from the day when you released from jail, from that day you are disqualified to act as director for a period of 5 years. If your imprisonment sentence is more than 6 months, say for example, if your imprisonment sentence is more than or equal to 7 years, you are permanently disqualified to act as director in your lifetime. You are not allowed to do, you are not allowed to appoint as a director in any company, public, private, OPC, Section 8, nothing. Permanently disqualified. So these are the rules. So imprisonment clear? Less than 6 months. Less than 6 months. More than 6 months but less than 7 years. More than 6 months but less than 7 years. Disqualified till 5 years. From the expiry of sentence, not from the beginning of sentence, from the expiry of sentence. Went on imprisonment for a period of more than or equal to 7 years. Then lifetime disqualification. The imprisonment ground is immaterial. The imprisonment ground is immaterial. Whether it involves moral turpitude or not, nothing, don't care. It may be drunken drive case, it may be murder case, rape case, divorce case, molestation case, whatever the case it might be. What is important is period of imprisonment. That is the only criteria. On that criteria, your directorship disqualification will be decided. Are we clear so far? What we have discussed, first point, unsoundment, clear? Second and third point regarding insolvency. Whether you are adjudged as insolvent or your application is pending before a court, in both cases you are disqualified to act as a director. And the fourth point is, you are clearly disqualified by any court or tribunal. The court itself is saying you are disqualified. So you are disqualified. Next one, achieved maximum number of directorships. Limit has been reached, no more appointments. Next one, imprisonment. 3 cases, less than 6 months, more than 6 months, but less than 7 years, greater than or equal to 7 years. These are the cases which we have discussed so far. Are we clear? Next one, convicted under section 188. 188 is a very important section which talks about related party transactions. Related party transaction. In that related party transactions, you made some scams or frauds and convicted. Then also you are disqualified to act as a director. Next one, not paid calls on shares till 6 months from the due date. It means call money. It is a very old point. In current days, call money, application money, allotment money, it is not there. Directly they are collecting entire money at a single shot. But being it is a rule, we have to discuss. So this point is, say for example, you are a director in a company and you are holding 100 shares. You paid application money, you paid allotment money. Regarding first call, second call, final call, whatever the call it may be. Regarding call money, company called you regarding the payment and decided a deadline. 1st June is the deadline. You failed to pay the money and the 6 months time has been elapsed from the due date. What is the due date for paying the call money? 1st June. From that 6 months. So after the expiry of 6 months, you will be disqualified to act as a director in that company only. That disqualification will not be attracted to another companies. In which company you are failed to pay the call money, the disqualification will attract up to only that company. It will not spread to other appointments and other companies. Okay, so in the above case, he or she is disqualified from that particular company only. you are disqualified to act as a director in the company in which your dues has been expired. Your dues has been pending from last 6 months. Not applicable to other directorships. Other directorships are in safe zone. Okay. So this is all about 164.1. 164.1. I think you all received the hard copies of the materials, right? You are following it? Okay, very good. So that is 164.1. And this is 164.2, very prominent and important section. Section 164 itself, it is a prominent and important section. Subsection 1, 2, 3 are also equally important. So 164.2 talks about company level disqualification. 164.2 talks about company level disqualification. So what is our discussion so far? Individual level disqualification. It talks about your personal abilities, personal traits, personal qualities, insolvency, unsound mindedness, imprisonment. It's all about individual disqualifications. 164.2 talks about company level disqualifications. So what is that company level disqualification means? Say for example, you are acting as a director in a company and that company failed to file financial statements or annual returns for continuous period of 3 years. You are acting as a director in a company and that company failed to furnish the financial statements or annual returns to MCA for a continuous period of 3 years. It is point number 1. Or this is point number 1. Point number 1 or point number 2. Okay, this is point number 1. Point number 2 talks about you are acting as a director in a company and that company failed to repay the deposits or repay the debentures or pay the interest thereon. You are acting as a director in a company. That company collected money from public in the name of debentures or deposit, whatever it may be. That company failed to repay the deposit or debenture principal amount or interest amount. And the period of 1 year has been expired from the date of default. That is the important thing. Just because company defaulted, you are also disqualified. No. A maturity period or a cooling period will be given. Say for example, I am acting as a director in a company and that company failed to repay the deposits or pay the interest. Just because that company failed to pay the interest, I am not disqualified. A maturity period, a cooling period will be given. That cooling period is 1 year. So from the date of default, what is the default? Company made default in repaying the principal amount or paying the interest amount. From that default date, 1 year time should be given. That is called a relaxation period anamata. Relaxation time. That relaxation time 1 year also elapsed. Now, whole directors of that company, whole directors including independent director, whole directors, whatever the empanelment of the directors in that company, all the directors will be disqualified. All the directors will be disqualified. So in order to attract section number 164 subsection 2, two conditions, any of the two conditions must be satisfied. Any of the two. Any of the two. First condition is what? Company failed to furnish the financial statements or annual returns for a continuous period of 5 years. 5 years. 3 years or 5 years? 3 years. And the second point is company failed to repay the principal amount on debentures or deposits or pay the interest among the deposits or debentures. Then also immediately the directors will be disqualified. Immediate disqualification. No. No. We have to wait till the expiry of 1 year. From the date of default. From the date of, say for example, deposits maturity date is 1st July. Deposit maturity date is 1st July 2024. That is a maturity date. 1st July 2025. You have to wait till 1st July 2025. Till that time, directors are not disqualified from their positions. Even after the completion of 1 year and the default is subsisting with the company, then the whole empanelment of the directors are disqualified. Sir, how far this disqualification will attract according to section 164.2? Listen carefully, this is a tricky section. Section 164(2) disqualification applies to further appointments. That means new appointments. Section 164(2) disqualification applies to further appointments, that is new appointments as well as reappointment in the same company. Reappointment in the same company, and will not be applicable to existing compliant directorships. Existing compliant directorships. Say for example, X is a director in ABC Limited, and for that company 164(2) disqualification attracts. X is also a director in 3 other companies. Along with ABC Limited, he is a director in 3 other companies simultaneously. So how many directorships he is holding? 4 directorships. Allowed or not allowed? Allowed or not allowed? 100% allowed. 4 directorships, na? 100% allowed. So he is a director in 4 companies. Out of that 4 companies, 3 other companies and 1 is ABC Limited. That ABC Limited failed to furnish the financial statements or annual returns for a period of 3 years, or failed to repay or failed to pay something, deposits, debentures, interest, etc., and the period of 1 year has been elapsed. Now Mr. X is disqualified. Mr. ABC Limited and other 3 companies also. Okay. Now Mr. X is disqualified to act as a director. Disqualified to act as a director in new appointment, new companies, as well as Mr. X is disqualified for further appointment in ABC Limited. That means 164(2) disqualification has nothing to do with the ongoing appointments. He is a director in how many other companies? 3 other companies, na? He need not vacate other 3 companies' directorships. He can continue in other 3 companies. This is a tricky section. Students will 99% tend to confuse in this section 164(2). On a plain reading, it might be appear to be easy section, but it is a tricky section. I am repeating again, listen carefully. 164(2) disqualification attracts to new appointments as well as further reappointment in the defaulting company. What is the defaulting company name in the given example? ABC Limited. Mr. X is disqualified for further appointment in ABC Limited. No more further appointments. Why? Because he made some mistakes. What is that mistake? Failed to furnish the financial statements or failed to repay the deposits or debentures, blah blah blah. Okay. So Mr. X is disqualified to act as a director in ABC Limited. Further appointments not allowed, as well as no new company appointments are not allowed. But ongoing assignments, ongoing appointments, he can continue. He need not vacate the ongoing office of the ongoing directorships office. Clear? Majority students will think that as and when 164(2) disqualification appears, he is disqualified from all appointments. No, that is a wrong section, wrong interpretation. And there is a one more tricky point also here. ABC Limited failed to do such thing, do some things, failed to furnish financial statements, failed to repay deposits, etc. Company is which person? Company can function along its own mentality or can take own decisions. Who is backed by the company? Board of directors. Company failed to do some things. That means who failed actually? Company or directors? Directors. Say for example, X, Y, Z, 3 members are the directors of ABC Limited. Beautiful point, listen carefully. Who are the directors? What is the company name? XYZ are the directors of ABC Limited. Okay. Now, ABC Limited failed to do some activities and 164 to disqualification attracts. Say for example, if XYZ vacated the office, XYZ vacated the office, who has to correct the wrong things? Some other persons will come and correct the wrong things. It means some persons will come and make the office as a shitty place, is a messy place, and some other persons will come and make this place as a right place. Who should be responsible for the mess? Who has created the mess? XYZ. So that person should be responsible for the messy things. That is why XYZ are disqualified to act as directors, but they should not vacate the office. They will continue in the office. They will be held responsible for the upcoming further future actions also. Disqualifications means, okay, let's go home and sleep peacefully. No, nothing. You are responsible for the non-filing and you are responsible for the failure of repayment and payment. Then make the things in a correct way and leave the office. So disqualifications means from next day onwards directors can vacate the office. No, nothing. Who created this mess? XYZ. So they should make this place as a better place. That is the rule. So 164.2. 164.2. It is a very tricky section. Understand carefully. There are two tricky points. First tricky point regarding the disqualification. For which companies disqualification applies? All companies. Not to all companies. Disqualification applies to new appointments as well as reappointment in the same default company. That's it. Ongoing appointments. Ongoing appointments he can continue till the expiry of the directorship. Nothing doing. No problem. He can peacefully continue with the ongoing companies. No new appointments should be made as well as no further reappointment in the defaulting company also should be made. This is the first tricky point, and the second tricky point is disqualification doesn't mean vacation of office. Disqualification doesn't mean vacation of office. They are disqualified. The act is saying they are disqualified. That's it. Okay. Act is not saying to vacate the office immediately and go home. Okay. That is a simple point in the 164.2 section, and I have clearly written here. Let's read out quickly. Company fails to file financial statements or annual returns for 3 continuous financial years, or condition is or and, or any of the conditions. Okay. Company failed to repay the deposits or debentures or interest thereon or dividend also. This is also important. Dividend also. And this default subsists for more than 1 year. Then such directors is disqualified for 5 years from the date of default. So no new appointments or reappointment in the defaulting company till 5 years. I forgot to tell this point. The disqualification applies to how much time? 5 years. But if he is already acting as a director in the other companies and they are compliant enough. Compliance means, in first class or second class I told this. Compliance means following the rules. Here compliant means following, not complaint. Okay. If the other companies are compliant enough, that means other companies are following the rules, then he can continue with the companies and he can continue with those appointments. This section applies to independent directors also. But relaxation and disqualification is allowed to new. This is a simple point. 164.2. In section 164.2, there is one relaxation. What is that relaxation is? Say for example, if you are a newcomer in the directorship empanelment, then from the disqualification you will be exempted. Sir, what is meant by newcomer? 6 months. Say for example, just now you are appointed as a director in the company. Hardly 3 months or 4 months or 5 months are elapsed from your appointment date. You will be considered as newcomer till 6 months of your appointment. Why? Because after appointment, you have to study the company, you have to study the transactions, you have to form an opinion regarding the company, right? So for that opinion formation, 6 months time will be given. Till that 6 months, you will be considered as a newcomer. So disqualification will not be attracted to newcomer directors. Okay, so this is one exempted point. Are we clear with 164.2? 164.1 talks about which disqualification? Individual level disqualification. 164.2 talks about company level disqualification, and 164.3 talks about additional disqualification which a company might include in AOA. Sir, what kind of conditions they may include? Depends upon the company's nature and behavior. But that disqualifications or restrictions, they should be well within the limits of the act. They should not override the act. Can AOA override the act? AOA can't even override MOA. Okay, AOA or MOA should not override act. You can place n number of restrictions, but those restrictions should be well within the limits of Companies Act rules and regulations. That's it. 164, 1, 2, 3 completed. Done. 164, 1 completed, 164, 2 completed, 164, 3 completed. 164, 1 talks about individual level disqualification. 2, 3, disqualifications mentioned by AOA. What kind of disqualification should be included? Depends. You can add n number of disqualification. It should be well within the limits of act. That's it. That is the only requirement. So these are the disqualifications. Na? Let's quickly understand about qualifications. I think 3 to 4 minutes are enough. We will conclude this session. So qualifications of directors. First one, only individuals are allowed. I hope you all are aware about this point. A company should not act as a director in another company. Next one, DIN is mandatory. Coming to the age requirement, for acting as a normal director, there are no age-wise restrictions in Companies Act 2013. For acting as a director in a company, there are no age-wise restrictions. Normal director. Normal director. But in order to act as a whole-time director or MD or manager, 3 positions. What are those 3 positions? MD, whole-time director, manager. Why? Why? Because MD and whole-time director, manager, these directorships, they will come under which category? Executive director category. What they should do? They have to involved in the day-to-day affairs of the company and should actively participate in the administration of the company. That is why physical fitness is very much important. That is why in order to act as MD or WTD or manager, age-wise restrictions are there. Minimum 21 years should be there for a person and maximum age is 70 years. Maximum age is 70 years. But you can appoint a person who is having more than 70 years also. But for that thing, SR is required. What is that SR? Special resolution. What is that SR? Special resolution. You can appoint a person who is having age more than 70 years also. But for that appointment, you have to place, you have to justify the shareholders. And 75% or more voting is required. Simply, special resolution should be passed in the general meeting for that appointment. That is the simple thing. For other directorships, no age-wise restrictions are there, but only thing is he should be capacitated enough to enter into the contract. In Indian Contract Act, what is the minimum age requirement for a person to enter into a contract? 18 years. That is the same requirement. No new additional requirements are placing by Companies Act 2013. The only requirement is if a person is capacitated enough to enter into a contract, he is qualified to act as a director. According to that provisions, what is the minimum age requirement for a person to enter into a contract? 18. That is the same thing, 18 years. But for MD, WTD, manager, 21 years. Minimum 21 years. Maximum 70. For above 70, for CEO. CEO, not there, na? CEO. CEO. Listen carefully. There is no such word called CEO in entire Companies Act 2013. It is a brought forward word from Western community. So Companies Act does not know about who is a CEO. What is CEO? In general, in the place of MD, CEO will be added. That is why I have already told you to understand the point regarding MD. Parallelly, can a company have MD and CEO? Who is saying yes? Huh? I have clearly communicated this point to you. I think 2 to 3 days, 2 to 3 sessions back. No company should have MD and CEO parallelly. And no company should have more than one MD. If you wish to have one MD, more than multiple MD, you can have in the name of joint MD. Okay, that is the point. So, minimum age requirement for a normal director 18. Maximum no disqualification. Minimum age requirement for a MD or WTD or manager 21 years maximum. After 70 disqualification, no disqualification. You are still qualified to act as MD or manager or WTD. But only thing is special resolution in the meeting should be passed. That is the only requirement. That's it. Okay. Next one, DIN mandatory. This is the process of obtaining DIN. And next one is no specific educational qualification. Even 10th fail or 7th fail person can also act as a director. Why? Because business expertise has nothing to do with education. Some people even without education, they will do miracles in business. Nilofer Kef, what he studied? Okay, Aditya Birla. Aditya Birla Group of Companies Chairman, Kumar Mangalam Birla. He's a chartered accountant. He is running successfully the entire group. After this is a separate case which I'm going to tell you in CGCSR case. There is a committee called Kumar Mangalam Birla Committee also. I'll discuss at that point. Next one. So no specific educational qualification requirement from Companies Act point. Even if you are an MBA or CA, CMA, 10th fail, anything, everybody is welcome. For appointment as independent director, some sort of qualifications already discussed, right? Person with integrity, honesty, blah, 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 etc. are required. That's it. So this is the process of obtaining the DIN. Tomorrow we will discuss, okay? Some spark is appearing on some students. Huh? Right. How we will obtain, what is the process of obtaining the DIN and what is DIN? It is a 8-digit unique number, valid for lifetime. There is an important point in DIN. This is that important point. Okay. We'll discuss tomorrow morning session. Okay. We'll discuss in that session. And after the after completion of DIN explanation, we'll discuss about appointment, reappointment, retirement, rotation, remuneration, resignation, etc. etc. Right. Okay. Thank you.